prosecutors should consider their respective country situations and advise when criminal law provisions are most relevant for application to domestic gender BV situations. Key questions that may be addressed are, for instance, could gender-based violence be adequately punished by a fine only? When will be the custodial threshold be passed for gender-based violence? That is, when does GBV become serious enough to merit imprisonment? How does member states reinforce the confidentiality of GBV reporting? Should the divulging of confidential information relating to GBV reporting itself be considered as an offense? Is prosecution always the right approach concerning gender-based violence? These are just a flavor of the questions that participants may dwell upon for further engagement with the legal drafter and facilitators of today's session. In addition, prosecutors are also invited to give their views generally as lawyers on the purview of the model law and its responsiveness to the GBV context for the SADC region. Having made the remarks as I have today, I wish to thank you again for your attendance today, and I wish you all a pleasant session. Thank you, Director of Ceremonies.
Thank you very much, Madam Secretary General, for your eloquent exposition. I do not wish to waste time to highlight what you said, and I think it's important that you zeroed on the character and essence of the SADC model law as soft law, and being able to be a booster or a catalyst, the words that you used, in our respective jurisdictions. But towards the end, I'm sure you touched on a number of practical issues that will resonate very well with prosecutors around offenses, around how they sift through cases to be able to make a determination that they proceed with prosecution on a particular matter, and also the issues you raised as to whether a fine is warranted, and if warranted, under what circumstances, and including imprisonment. I think those were practical issues that prosecutors will relate with, and in particular, whether imprisonment, is it always the right way to go? So thank you very much for raising those important issues around prosecution. It's now my pleasure to invite my good friend and dear sister, Veronica Mhlaba, who is a judge of the High Court in Malawi, and very engaged on issues of human rights generally, a member of many judges forums, including Africa Regional Judges Forum, and including Judicial Action Group, of which we are both members. And she's also a member of the Women Judges Association of Malawi, and she's passionate about development issues as well as women and child rights issues. And Justice Ntaba is a former prosecutor, and that was the attraction to get her to come and address us today. So my dear sister, it is my honor to call upon you to give us your keynote address. Justice Ntaba.
Good morning. Thank you very much, Judge Nikake. It's always a pleasure to be in any forum with you, especially when it comes to discussing issues of justice and human rights. So I bring you greetings all from the warm heart of Africa, Malawi. I live in a country that's blessed with beautiful people, rolling hills, thirst-quenching rivers, and an amazing lake, only called the Lake of Stars or the Calendar Lake. So I invite you, since we are all being vaccinated, once tourism hits its high, to visit us one of these days and come enjoy our coffee, our fish, but more so our amazing water. Let me first say that it is great to be among a set of people in the legal profession who I enjoy interacting with, being a former prosecutor myself. It is therefore an honor to address you at this SADC Gender-Based Violence Model Law Consultative meeting for prosecutors from the SADC member states, being held virtually. It is important to note that these consultative meetings are happening at a highly appropriate time right now on the African continent, as every country is continuing to grapple with gender-based violence and its impact on the population, as well as its economic prosperity and development of its people. Therefore, my keynote address is suitably placed in this discussion that Africa needs to have at this point, but more so for the SADC countries, which have their own unique issues in terms of gender-based violence. Let me state from the onset that I find the objectives of the consultative meeting exciting and extremely important, as the issues you aim to achieve are very fundamental for gender and women's rights across Africa. It should be indicated that there will be a lot of discussion on women's rights and girls in this address. It is evident that even in the 21st century, research has shown that most sectors continue to move at a glacial pace in terms of bringing women and girls into a position of achieving highest development, but more so enjoyment and promotion of human rights. Estimates published by WHO in March 2021 still indicate that globally 1 in 3, that is 30% of women worldwide, have been subjected to either physical and or sexual intimate partner violence or non-partner sexual violence in their lifetime. Further, that most of this violence is intimate partner violence. Worldwide, almost 1/3, which making it 27% of women aged 15 to 49 years who have been in a relationship report that they've been subjected to some form of physical or sexual violence by their intimate partner. Incidentally, that violence against women and girls, particularly intimate partner violence and sexual violence, is a major public health problem and a violation of women's human rights. Therefore, as prosecutors, we should be very concerned and be working on ensuring we reduce these numbers. Distinguished prosecutors, I've gone through the draft SADC model law, and I wish to applaud the SADC Parliamentary Forum for having taken on this task, which is critical and pivotal in the justice sector. Most of us hail from countries that have constitutions that emphasize human rights, including mine, where under Section 19, it provides for the inviolability of human dignity. It prohibits torture, cruel, inhuman, and degrading treatment. Gender-based violence bears the mark of torture and is also under various circumstances cruel, inhumane, and degrading. The invasion of the body in sexual offenses, contrary to the wishes of the victim's wishes, in a sexual manner often leaves the victim traumatized, both physically and psychologically violated. It is a fact that consequences of gender-based violence means unproductive citizen, and this equates to a lack of development for the citizen, the nation, and the continent as a whole. It is therefore imperative that as a SADC, we move and embrace new ways of handling gender-based violence. The words of Gubei, Justice of Appeal in Banana State, are very poignant and speak to the need to adjust, especially in dealing with issues in the gender-based violence context. They stated that in the present-day society, there was no rational reason to apply a cautionary rule in cases of sexual nature. This followed changes in neighboring jurisdictions like South Africa and Namibia. Gubei, J.A. quoted with approval the Namibian judgment of S versus D and another, in which the following was said: in the end, only one test applies, namely, was the accused's guilt proved beyond reasonable doubt, and the test must be the same whether the crime is theft or rape. He also quoted with approval the South African judgment in S. and Jackson, in which the following was said: in my view, the cautionary rule in sexual assault cases is based on an irrational and outdated perception. It unjustly stereotypes complainants in sexual assault cases, overwhelmingly women, as particularly unreliable. In our system of law, the burden is on the state to prove the guilt of an accused person beyond reasonable doubt, no more and no less. So I'm therefore particularly pleased that this meeting affords us an opportunity to share knowledge and experiences on this very important topic, and in the process of building a body of knowledge that can be used to perfect the draft model law. However, it would be remiss of me if I did not pick out a few areas in the model law, which in my opinion need further examination, especially taking into consideration the role of prosecutors in the criminal justice space. Recently, the COVID pandemic has resulted in many of our countries registering alarming incidences of gender-based violence. The model law has included a very critical area, which several of the SADC jurisdictions have very little legislation on. That is the concept of femicide. WHO states that globally, as many as 38% of all murders of women are committed by intimate partners. The model law only highlights femicide under the definition part, but fails to expand it in terms of the legislation or offer enough insight to the various countries in terms of how to adopt and adapt the model law in terms of it. The model law fails to provide parameters for prosecution institutions in dealing with femicide, including prioritization of prosecuting such cases, charging aspects to mention a few. It should be noted that femicide, especially in honor killings or domestic situations, need to have different focus in terms of prosecution policies in our various countries, and the model law needs to ensure such is properly highlighted. Let me also take this opportunity to also address a critical issue which needs to be fully embraced and noted in the model law when it comes to the implementation of the law itself, especially as it relates to the prosecution, which moves beyond training envisaged in Section 72 of the draft model law, especially on the concept of revictimization. The law needs to address revictimization to be beyond access to justice, but to be envisaged as an extension of the medical principle, first do no harm. And that is to be addressed across the gender-based violence continuum of a victim. Whilst in terms of prosecution, this should include the parameters to be addressed and ensured pre, during, and post-prosecution. Carmichael versus Minister of Safety and Security and another buttresses the importance of prosecution doing their duty. The High Court and Constitutional Court held that the common law of delicts required development to reflect the constitutional duty on the state, especially the police and the prosecution, to protect the public in general and women against the invasion of their fundamental and guaranteed rights by culprits of violent crime. The court held that the minister liable in a case of rape for negligence because the state did not take measures to protect the victim, including the prosecutor who had failed to inform the presiding officer that the accused had previously physically assaulted the victim so that he was not afforded bail. Similarly, Mexico's Supreme Court issued a historic order where the court analyzed the conduct of each public servant involved in the case and revealed how the absence of a gender-sensitive approach had led to human rights violations of the victim, Mariana Lima, the deceased, as well as her mother. The court also issued legal protection of Rienia Budea, who was the mother. Eventually, Julio Hernandez Balinas, who was the culprit, was arrested since the order required Mexico state authorities to reopen the case, but also to conduct the investigation from the perspective of femicide or the murder of a woman by a man for reasons related to her gender. It can be said courts have played and continue to play their part in protecting women's rights. They have consistently highlighted those women and girls continue to face numerous inequalities, but also vulnerabilities to their well-being and safety. On the African continent, this is worsened due to the patriarchal nature of our society. It is my belief that most courts are moving towards gender-responsive judging as well as service delivery. Therefore, it is critical that prosecutions also inherently adopt policies, systems, and processes that are gender-responsive, as they can affect delivery of justice if they do not. Lastly, it is recognized that our courts have made significant strides in the jurisprudence involving women and girls in terms of gender-based violence. However, there is some gap when it comes to men and boys who are faced with gender-based violence. Therefore, the issues of gender responsiveness are critical. Consequently, the model law needs to also address aspects of this in terms of how the system is viewing incidences of violence perpetrated against men and boys. Internationally, despite the context being highlighted here is conflict times related, the significance cannot be underplayed. In the prosecutor versus Bosco Tanganda, which concerned the Forces Patriarchs for Liberation of the Congo, an armed group comprised of people from the Hema ethnic group, which was a party to the 2002-2003 DRC conflict. It was recorded that at the pre-trial and trial stage, the defense sought to have charges of sexual violence against FPLC child soldiers excluded on the basis that the alleged conduct could not be a war crime because the putative crimes and perpetrators belonged to the same military force. However, the appeals chamber rejected that argument and confirmed that the rape and sexual enslavement of child soldiers by their commanders can indeed constitute war crimes under the Rome Statute. The trial chamber held that the OTP provided several of the allegations of rape, that is, the Office of the Prosecutor provided several of the allegations of rape and sexual slavery against child soldiers beyond reasonable doubt, and that Tanganda bears individual criminal responsibility for those crimes. It was also convicted Tanganda for acts of rape and sexual slavery committed by FBLC troops against non-Hema civilians, both male and female. Further, in addition to these sexual violence crimes, Tanganda was convicted of conscripting and enlisting child soldiers, using them to participate actively in hostilities, attacking the civilian population, murder, attempted murder, prosecution on ethnic grounds, forcible transfer and displacement, attacking the protected objectives, pillage, and destruction of property. Therefore, he was held responsible for these crimes as a direct perpetrator and indirect co-perpetrator. Accordingly, there is need for prosecutors in the SADC region to note that there is mounting evidence that gender-based violence committed against men and boys needs to be receiving increased attention as well. Access to justice remains a key pillar towards the eradication of violence against women and girls. It contributes to breaking the cycle of violence, provide adequate reparation to victims, and transform the circumstances that make women and girls vulnerable to violence. Enhancing the efforts of prosecutors as part of key justice responders in protecting the rights of women and girls, as well as men and boys, is essential, and the model law does so. It is important to highlight that we must continue to be determined in terms of promotion and protection of the rule of law, with a special emphasis on advancing human rights of everyone, but more so women and girls who continue to be vulnerable despite a lot of efforts. Justice dispensation is a collective determination and effort of every person in the sector. Justice must be transformative and must have a human rights face. It is therefore imperative that prosecutors across Africa should be strategic and harness all its resources. We nonetheless commend our legislators for taking such a huge, bold step in drafting this model law. It gives us, as judiciaries as well as prosecutors, a good basis for expanding laws on gender-based violence in our various jurisdictions. It offers prosecutors opportunities beyond the criminal justice space, including advising victims on other possible actions available, like taking the civil route in addition to the criminal justice route to redress human rights violation. The need to protect women and girls from unwanted violence cannot be overemphasized when we talk gender equality, including women's rights. We must, and I stress must, be present. In conclusion, let me leave you with the words of the Dalai Lama, who said, "Peace can only last where human rights are respected, where the people are fed and where individual nations are free. We must be ready, we must remain ready, we must remain vigilant, but more so ready to reduce the inequalities, but also prosecute with vigor gender-based violence cases in our countries." I wish you a wonderful consultative meeting, as well as wishes as you continue to help eradicate gender-based violence across the SADC region. Thank you.
Thank you very much, my dear sister, Justice Ntaba, for that elaborate and comprehensive exposition of the issues of moment, especially that we are today dealing with prosecutors. I think you highlighted the foundation of it all. The foundation of it all is human dignity, which is inviolable. And if we appreciate that that is the foundation of it all, that all other rights spring from the mere fact that we have the right to human dignity and not to be treated in any manner that is cruel, inhumane, or to be tortured, as justice indicated. And I'm very also thankful about constant references to case law that you alluded to, which can the prosecutors can benefit from, especially the remarks of Dubey CJ dealing with cautionary rule and many other points that you raised. And the other point that did not escape my attention is that there is also increased attention that prosecutors must be alive to gender-based violence against men and against boys. We should never make the mistake at any time to think that when you talk about gender-based violence is something that excludes men or is something that excludes boys. It is about women, girls, and boys, save, of course, the fact that stares in the eyes that gender-based violence is disproportionately at very high rates experienced by women and girls. So thank you very much, Justice, for those remarks. I will now move to the next stage of our proceedings. And we don't have any testimony from a gender-based violence survivor. So we will move to the next speaker. The next speaker is Linda Nedu, the National Project Officer for Gender-Based Violence from the United Nations Office on Drugs and Crime, UNDOC Regional Office in Southern Africa. She will deliver within the time frame indicated in the program 2 background papers that speak to gender-based violence as a human rights issue and also highlight some gaps or shortcomings in the gender-based violence laws in our region in a summary form. Linda, it's my pleasure to give you this opportunity to address us on this very important topic. The floor is yours.
Thank you very much, Program Director. Good morning, esteemed guest, ladies and gentlemen, Madam Secretary General. I stand on the current protocols and I ask my colleague Nolu to share my presentation. Nolu, are you there?
Yes, Linda, I am here. I am sharing just now. Thank you.
Thank you so much. Just to continue, Program Director, I'd like in my presentation, as you indicated, to provide an overview of gender-based violence as a human rights concern, as well as to provide an overview of the GBV legislation that exists.
Sorry, Linda. Sorry to interrupt you. Can I ask the host to please give me rights to share screen? Thank you.
Wilfred, are we winning? ICT? Wilfred?
Yes, sir. Yes, sir. Sorry, I had a small issue on my side. I'm here.
Yes, you had Nolubabalo needs to be given rights to share.
Okay. I'm editing it right away.
Sure.
They should be able to share right now.
Okay. Thank you, Wilfred.
All right, sir.
Okay, thank you very much. I'm going to go on to the next slide, which provides an overview of my presentation. And ladies and gentlemen, as indicated, I'm going to provide an overview of gender-based violence as a human rights concern, as well as provide you with an overview of the legislation within the SADC region and important international frameworks that influence the SADC region. With that, I take you forward with regards to understanding the concept of gender-based violence. So violence that occurs as a result of the normative role expectations associated with the sex assigned to a person at birth, as well as the unequal power relations between the genders within a particular context, is known as gender-based violence. And when we look at the various forms of gender-based violence, we find that it actually exists or manifests in physical, economic, sexual, psychological, structural abuse. And when we look at structural abuse, we look at unequal, exclusionary economy that does not consider women's rights. And when we look at the various manifestations of gender-based violence, we find that it exists in the form of rape, sexual harassment, trafficking, sexual exploitation, harmful cultural and religious practices, and cyber violence. And when we look at harmful cultural religious practices, we find that it differs from country to country. But most commonly, the consequences of harmful cultural and religious practices result in female genital mutilation, child marriages, but just punitive measures against women because of their relative gender. And I think our guest speaker focused a great deal on femicide, and I really appreciate that because we find that this is sadly lacking cognizance of the issue of femicide, killing of a female person or perceived female person is generally lacking in current legislation within the SADC context. And we find that gender-based violence is also a result of violence that occurs as a result of one's sexual orientation, gender identity, and expression and sexual characteristics. Then we also have state violence in which women and girls are denied access to sexual reproductive health rights. And this has grave repercussions because consequently it results in STDs, HIV, unwanted pregnancies, and sometimes death. And we find that, when we look at harmful and cultural sexual practices, we find that women are actually forced into particular practices that result in their rights being violated under the guise of traditional and religious and cultural practices. And this is denounced in international human rights agreements. The respect of human rights requires that we respect the rights to bodily autonomy, health, dignity, integrity, and we need to reinforce the inequality of women. Next slide. As indicated, gender-based violence disproportionately affects women and girls globally. And we find that gender-based violence exists within different contexts, whether it is public or private, in various relationships, in peacetime, armed conflict situations, And we find that gender-based violence affects women throughout their life cycle, whether they are young as children or whether they are aged. And we find that gender-based violence is exacerbated by cultural, economic, ideological, technological, political, religious, social, and environmental factors. In whatever form gender-based violence exists, it results in harm, suffering, threats of coercion, and the arbitrary deprivation of liberty. GBV is enabled by the prevalence of gender inequality and is rooted in patriarchal gender and social norms, economic injustices, poverty, education, and sometimes predisposed, and most often we find in research, by alcohol or drug abuse. We find that gender equality is a right to be free from discrimination and to be treated equally, which is an international human right and also agreed on in the global goal and the Agenda 2030. Next slide. With regards to statistics around gender-based violence, we find that globally, 18% of women experience violence by an intimate partner. And this occurred in 2020 when a particular survey was done. But globally in 2017, 190 million women who wanted to avoid pregnancy did not have access or were able to use a contraceptive method. In the SADC region, we find that the major forms of sexual violence in the region include rape, trafficking in persons, and child marriages. And in 7 countries, 20% of women between 15 to 24 years reported sexual violence from an intimate partner. And the percentage exceeds 50% in many countries. So we find that commonly women experience this violence in their intimate domestic relationships. Sexual violence against adolescents aged 15 years is highest in the conflict and post-conflict countries. Next slide. In a research that was done by UNODC globally, we found in 2017, 87,000 women were killed, and 30,000 of these were killed by intimate partners, others by family members, etc. In 2017, the highest rate of female victims of homicide by intimate partners were recorded in Africa, with 1.7 per 100,000 females. So the number of women killed by intimate partners, family members, is higher today than what it was estimated in previous years. So obviously, it is common knowledge. The home is the most dangerous place for a woman. Women continue to be affected by this type of violence to a greater degree than men, which is indicative of an imbalance in power relations between women and men inside the domestic sphere. Next slide. And when we look at the impact of gender-based violence, we find that violence against children and women are linked. We find intergenerational cyclic patterns that are well established in research, with boys more likely to perpetrate and girls more likely to become victims as adults when they've been exposed to childhood violence. Also, we find that costing studies indicate that gender-based violence is a high and costly expense to any country. The social costs are also extremely high, and it compromises the sexual and reproductive health, the mental health, the social well-being, productivity, mobility, and capacity of women survivors to live healthy, fulfilling lives. And the traumatic effect has multiplying effects on women and children, with mental health problems becoming the most common area. It also, gender-based violence inhibits women from decision-making within the household, at work, at a political level, economically, in social spheres, and it impacts on their participation in public activities and in exercising their citizenship, which is their right. Social and political significance of gender-based violence also include the inaction of society at large to defend the human rights of women by denying them a public and individual discussion of these crimes. We also find that within COVID, within the context of COVID-19 or other emergency situations that have actually faced society, that these crises are never gender neutral, whether it occurs in conflictual situations, in situations of terrorism, or currently COVID-19. Women and girls are hurt by the economic and social fallout of COVID-19. The analysis done by the United Nations, as projected for 2021, indicated that 435 million women will be living on less than $1.90 a day, and 47 million in poverty. COVID-19 has palmered, feminized labor sectors, especially because most women work in the informal sector. In 2020, globally, 240 million women and girls between the ages of 15 to 49 subjected to sexual and or physical violence with an intimate partner were actually projected. The emerging data show that violence against women and girls has intensified since the outbreak of COVID-19. And violent partners may use confinement, as they did, to further exercise power and control. At the same time, women have less income, fewer opportunities for social contact, which results in them having limited access to services and community support, all of which give them fewer exit options out of that abusive relationship. And then when we look at the issue of reporting, next slide, we find that globally, less than 40% women who experience violence report these crimes and seek help. Within the SADC region, victims generally do not seek legal recourse because of inhibiting factors such as the fear of being blamed for breaking up the family, fear of reprisals from their spouse, shame about airing their personal affairs in public, and also because they are economically dependent on their partners. Furthermore, a belief that police or legal agencies will not back them up and are generally ineffective in their eyes. Women usually blame themselves for the violence because of the cultural and social norms that are reinforced. Women also internalize social values that see female subordination as natural. They also accept cultural norms that regulate a couple, the roles of a spouse or mother, and idealize the family and marriage and the dominant cultural mandates, hence keeping them from ultimately reporting gender-based violence that they're exposed to. And when we look at the SADC, the legislation frameworks within the SADC region, and we find that the SADC protocol on gender and development seeks to promote gender equality in the SADC region, dealing specifically with gender-based violence. In part 6 of the SADC protocol, it indicates that state parties must enact and enforce legislation prohibiting all forms of gender-based violence and ensure that perpetrators of gender-based violence including domestic violence, rape, femicide, sexual harassment, female genital mutilation, and all other forms of gender-based violence are tried by a court of competent jurisdiction. Despite the existence of some gender-based violence sensitive legislation, gender inequality is still widespread due to existing gaps and limited enforcement of the laws in the SADC region. In addition, one of the shortfalls in gender-based violence legislation is the inability or reluctance by governments to follow through on their commitments, evidenced by their lack of ratification of international legal instruments. And then when we look at the international human rights framework, we find that international human rights laws are presented by various legal instruments, which offers a guide on practices in gender-based violence. And we find that international human rights framework is a system, it's a multi-system of conventions, treaties, declarations, implementation, committees, and reports on the protection of human rights. The founding document or instrument is the International Bill of Human Rights, which compromises the 1948 Universal Declaration of Human Rights, the 1966 International Covenant on Civil and Political Rights, the 1966 International Covenant on Economic, Social, and Cultural Rights, which all are drafted under the auspices of the United Nations. Other international human rights refer to the International Bill of Rights, which is supplemented by human rights treaties, which actually look at the protection of specific vulnerable groups, like the Convention on the Rights of the Child. The Sustainable Development Goals also provides for the prevention and mitigation of gender-based violence. In particular, I want to highlight Sustainable Development Goal 5, which refers to gender equality, and the SDG 16, which refers to peace, justice, and strong institutions. There are various resolutions as well taken by the UN General Assembly, but I want to highlight one particular resolution which focuses on the intensification of efforts to eliminate all forms of violence against women. The UN updated model strategies and practical measures on the elimination of violence against women and girls in the field of crime prevention and criminal justice, and that is Resolution 65 of 228. When we look at the African human rights framework, we find that there are many human rights instruments that prohibit gender-based violence, and regional treaties, monitoring, and judicial bodies can provide an important source of norms for combating gender-based violence. In particular, we find that the African Union's Agenda 2063 identifies gender-based violence as a major obstacle to human security, peace, and development, often fueled by armed conflict, terrorism, extremism, and intolerance. The protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, the Maputo Protocol, brings to the forefront the need to eliminate gender-based violence. Over and above that, we also have the SADC strategy on the sexual and reproductive health rights, 2019 and 2030, that is important human rights framework. And of recent, the recently developed regional strategy and framework of action for addressing gender-based violence, 2018 to 2013, is another important framework for the SADC region. In the last decade, gender-based violence legislation in the region has significantly improved. And gender-based violence services have improved. We find in particular some strengths. we find that 11 SADC member states have laws on domestic violence, 13 on sexual assault legislation. With the exception of one state, all SADC member states have sexual harassment laws. And currently, all SADC member states now have laws on trafficking in persons. And this is a major jump from just 3 in the year 2009. All member states offer some form of services to survivors of gender-based violence. Unfortunately, most of these services are provided by non-governmental organizations who are under-resourced and have limited capacity. And when we look at the gaps in legislation in the SADC region, we find that legal frameworks in 12 member states discriminate against women in that they have no or limited definitions in accordance or compatible with CEDAW Article 1. We also find limited provision in the law for legal aid for women facing gender-based violence, and this exists in 13 member states. In 7 member states, we find gaps in laws covering nationality, statelessness, and internal displacements. Also, the criminalization of abortion in 13 member states result in unsafe abortions and a high mortality rate. In 7 member states, disadvantaged groups of women, lesbian, bisexual, transgender, intersex persons face multiple and intersecting forms of discrimination, hate speech, and stigma due to the law not being adequately compliant or willing to address these particular issues. We find other gaps that exist in the SADC region. We find that 5 member states do not have labor laws that adequately deal with sexual harassment issues. 4 member states have criminalized child marriages, but 12 member states have no limited child marriage legislation. 15 member states have limited recognition of online sexual abuse exploitation in cyber laws, which offers ultimately poor protection of women and children against cyber gender-based violence. In regards to marriage and sexual offense legislation in the SADC region, although it exists, it has loopholes which infringes on the rights of women, including the issue of polygamy, marital rape, as well as property rights. And there's limited consideration to the definition and inclusion of femicide and gender-related killings. In conclusion, ladies and gentlemen, we take and we recognize that gender-based violence against women is a regional problem with devastating effects on individuals, families, society. It's a violation of human rights, and the law is an important governance tool that can ensure that states respect, protect, and promote human rights. Violence against women and girls is an obstacle to the achievement of the Sustainable Development Goals and the realization of human rights. Member states should take cognizance of its context, the voices of women, the drivers of gender-based violence, and the magnitude of gender-based violence within a particular context to ensure that they localize their responses and appropriately address the issue of gender-based violence. And we also find that women experience a continuum of violence, which often escalates into gender-related killing. We also find member states, next slide, Nolu. Member states are obligated to educate the citizenry of the pervasive nature of gender-based violence so that everyone, women, boys, men, everyone takes responsibility for gender-based violence, to look at how it is that they can actually counter this major pandemic. Gender-based violence response requires a holistic, sustained, coordinated, multi-sector approach, and importantly, a strengthened criminal justice response. Overall, gender-based violence requires a whole of society approach. Importantly, we need to look at how we can build social connectiveness towards a healing, because as long as we don't do that, we'll be continuously experiencing the repercussions of cyclic patterns of gender-based violence. With regards to that, we need to look at how we can draw on and bolster a sense of community towards healing, rebuild the social fabric, and break these cyclic patterns of violence. Also important, we need to recognize the intersections of violence against children and violence against women to be considered in interventions. If we don't recognize these linkages, we will not disrupt cyclic patterns of disruption. For instance, we need to look at how can we teach children non-violence dispute resolutions. Furthermore, ladies and gentlemen, states have an international obligation to prevent, investigate, prosecute, punish violence against women, ensure equal access to their justice, their protection, and look at how we can address remedies for victims and survivors. The credibility of a government's response to gender-based violence is sourced from the strength of its laws, how we implement it, and how we prioritize these particular crimes. And we find from the analysis of the legislation that member states have an uneven landscape in respect of their legislation, policies, implementation, and enforcement, which is overall not satisfactory. We also find that member states have a gender-neutral legislation in most areas. And these are required to be gender sensitized, which focuses on women as victims and as caregivers. We also need to look at the recurring lack of access to essential services for the safety, protection, recovery of survivors, and look at how we don't consider adequately the punity against offenders. We also need, ladies and gentlemen, to look at the lack of accountability, inadequate resourcing of gender-based violence implementation, the victim unfriendliness of services, the capacity challenges of resources that serve women and women and children against to counter violence. And we also need to take cognizance of the research and data limitations that exist around gender-based violence. Because as long as there's research and data limitation, we don't consider the adequate parameters of the incidence of gender-based violence. And we find that gender-based violence remains undocumented, underreported, and unaccounted for. Reliable and credible data is a bedrock for policy formulation and play a key role in informing, planning, costing, implementation, evaluation, and reviewing of programs and policies. With that, ladies and gentlemen, I thank you for listening, and I hand over to you, Program Director. Thank you.
Thank you very much, Linda, for that elaborate discussion. I think it has helped focus the participants, the prosecutors on and the phenomenon of gender-based violence. You have traversed the whole issue of why gender-based violence is a violation of human rights. You have also given us an overview, given the time frame we had, around the gaps that are there, and also alluded to the fact that there has, in actual fact, been improvement in legislating on issues of gender-based violence. But you did point out that there are still many challenges to overcome. Towards the end, I think, and of course you made mention of sobering statistics around gender-based violence. And one point that maybe the prosecutors can take note, of course, is that the home remains, in your words, the most dangerous place for women. What it may communicate to prosecutors is that they should not retreat from the home in terms of investigating issues of gender-based violence. And towards the end, you hammered the point home in making two remarks, which I deem appropriate to highlight too, for the benefit of participants. You said states have an obligation to prosecute and punish GBV against women. I think that statement, you are speaking directly to prosecutors who have the constitutional obligation to investigate commission of crime, by pointing out that in terms of international law, states are obliged to prosecute and punish for gender-based violence. And you made the related point that the credibility of government response to GBV is measured on the laws that are in place, and of course, not just that they are in place, and also their implementation. So thank you very much for those remarks, Linda. Much appreciated. I think the prosecutors, all the participants here have taken note. And I must also thank you for saving a few minutes. I think you have saved a few minutes, 8 or 7 minutes. So the next presentation is going to be made by the Director of Proceedings, myself, on gender-based violence, the modern law. I'm going to make a presentation giving you a flavor, a taste about the essence of the gender-based violence model law that has been drafted by SADC PF, and the one with respect to which we are consulting you and hoping to have your insights into whether there is anything that we need to be strengthened. And Justice Ntaba has spoken about certain aspects around femicide that she says we must look into, whether the parameters have been sufficiently prescribed or set. That is what we'll do. We hope that you'll also share with us, because we do not just give these presentations for the sake of it. We give them in order to benefit from your own experiences in engaging with matters of gender-based violence. And whatever experience can strengthen the model law is highly appreciative. And that is the very essence of our consultation. We do not purport to know it all, to know everything. We acknowledge that we know very little and that we can only benefit from you. So the presentation I'm going to make does not attempt to present the entire provisions of the SADC model law. That is an impossible task given the time we have and also the number of provisions in the model law. I'll only seek to give you an overview and highlight the key elements of the model law. And I'll try as much as possible to also touch on those aspects of the model law that apply directly to you, the prosecutors. So I will not necessarily follow the numbering of the GBV model law, but the model law, you may have noticed, is divided into about eight parts. Most of these parts deal with matters of general application. And for my purposes, for practical purposes, my presentation is going to be centered around 3 parts. The first will be the general provisions for you to appreciate the general essence of what the model law is all about. And that aspect has been eloquently dealt with by the Secretary General of the SADC PF. I'll elaborate on it a bit to underscore some of the things that she mentioned that define the model law, so that you appreciate what kind of animal we're dealing with when we speak about the SADC model law and how useful it could be to your work as prosecutors. And then on the second part, I will deal with the human rights dimension of the model law. And again, this part has been dealt with extensively by Linda in the last presentation. And lastly, I will try to deal with some provisions that are of importance to you. These provisions deal with access to justice, because you as the prosecutors are a key cog in the machinery of justice. You are the people who go out to investigate these crimes. And once you have found that you have evidence upon which to convict, you bring these matters to court. So I'll deal with those issues, including access to the courts and so forth. That was by way of my preamble to the presentation that I'm going to make. I apologize, I'm not as sophisticated as Linda in sharing the PowerPoint presentation on the screen. That is just part of the explanation, but the most fundamental one is that I think that I'm not used to it and I have no preference for it. I think it tends to slow me down. So you will pardon me on that. So I'll start with the first point around the SADC model law on gender-based violence as a guiding tool. This point has been made already by the Secretary General. So the SADC model law on gender-based violence is a tool. It's a tool, is a resource that all the stakeholders in the justice administration, including prosecutors, can have recourse to. They can consult from time to time and understand what it says, and even maybe get some resources or references that are referred to in the model law itself, especially the international legal instruments, the regional legal instruments that are referred to in this model law, which I'm going to highlight in the course of time. You can use it as a resource to refer to them. The gender-based model law is therefore useful for member states from that perspective. It serves to guide and also to encourage national parliaments to enact GBV laws that are consistent with international law, that are consistent with international human rights, including the Universal Declaration of Human Rights of 1948 and other subsequent conventions that deal with human rights. So this model law is consistent with the international legal instruments and the regional legal instruments, declarations, and resolutions that compendium, that all constitute what the Secretary General referred to as soft law. That although it may not be binding per se in its current form, it can be a very useful resource. It can be persuasive. It can be used by all stakeholders in the administration of justice. So that is the model law as a guiding tool. So it is plain, therefore, that the GBV model law will be a governance tool to assist member states to develop and enact appropriate laws. What is the rationale? The rationale has been stated already, that GBV is considered an affront to human rights. It violates the right to human dignity. And the international legal instruments that we have spoken about frown upon torture, inhuman and degrading treatment, which gender-based violence is about. So that is very important to bear in mind. So the overall objectives of the gender SADC GBV model law is to ensure that such a law is enacted, and after it is enacted, then it can be enforced. So the key objective of model law is to set standards. That's very important. Is to set standards, is to set principles, to hold member states accountable and assist them in developing the law. And also to provide for legal rights, to provide secure legal protections, and to ensure that victims have access to the law that is also victim-centered. So this is the very essence of the model law on gender-based violence. The form it takes should not detain us.
ICT.
I believe the judge has a problem on his side.
Is there a cross line? Because I hear someone speaking.
This is Wofi.
There's a voice. Kindly contact the judge and find out what could be the problem. Thank you.
All right.
Following up with you, Messi. Colleagues, apologies. We're trying to establish contact with the judge. I propose that we take a 10 minutes break while we are sorting that issue out, and then we come back at 20 minutes to 12. Thank you very much. Welcome, Justice. We briefly lost you. I want to confirm that we can hear you now. Hello, Judge.
I believe his audio is still connecting, so he
okay.
can hear us.
Justice, you are muted.
Hello.
Yes, welcome back. We lost you momentarily. We had agreed to take a 10 minutes break just to allow you the time to come back into the meeting. If it pleases you, we can commence at 20 minutes to 12, just in case some of the participants may have left the meeting when we agreed to take the short break.
Oh, okay. So we're coming back when?
11:40. 20 minutes to 12.
I'm using my phone.
Yes, Judge, you're still breaking a bit.
I'll say I'm now using my phone.
Ah, okay. No, apologies.
Yeah.
So sorry.
All right. All right. So I'll wait for the next 7 minutes, you say?
Yeah, sure.
All right.
Thanks.
Yes, Kurasha.
Yes, sir.
Okay. You were calling me. Okay.
Yeah. That was tracking. So I'm sorted.
I think the 10 minutes are over. Kurasha?
Yes, sir. You have the floor. We can proceed with the meeting.
Thank you very much. I apologize for the disconnection. The internet just evaporated, but is back. I was still on the issue of form, and I was making the point that the SADC model law follows the form of the previous other model laws. But it's crafted in such a way that it should be easy for national drafters to develop their own law. And the contents provide the best practice provisions, as I said, derived from various regional and international commitments. So basically, its provisions could be copied and pasted by national drafters into their working drafts. And as we'll all appreciate, the ultimate success of this SADC model law on GBV is when our parliaments domesticate the model law into national law, so that you, the prosecutors and other justice sector players can then use, they can then implement. So the ultimate success, we agree, of this model law is domestication. The SADC model law uses very simple language. It uses the means or includes rule to draft definitions to ensure that there is no ambiguity at all about what gender-based violence means. So you'll find this in the model law. So the preamble of the model law, like any other preambles in legal instruments, is particularly useful in the sense that it takes a quick snapshot or summation about the essence of what is at play. So in this particular case, the preamble of this model law, you realize, is quite long, but its value, as far as I'm concerned, is that it states critical international and regional provisions that have actually informed this law. So the preamble, actually, you'll find in the preamble the instruments that have actually informed this law. I'll mention some of those for your note-taking. And as I said earlier, you can then cross-reference later with these provisions. The first one that the preamble speaks about, that it has taken into account its provisions in formulating it, is the Universal Declaration of Human Rights of 1948, that reaffirmed humanity's faith and commitment to human rights. All this theme you have heard throughout the day ring unceasingly human rights. It derives authority from the Universal Declaration of Human Rights of 1948. So the preamble of the SADC model law is clear that that is one of the inspiring instruments. And then, secondly, it makes references, it acknowledges the importance of the Southern African Development Community Declaration on Gender and Development of the 8th of September, 1997. And it also refers to the SADC Treaty, the legal basis that constitutes SADC. The SADC Treaty is referred to in the preamble as part of the inspiration for this model law. And also the Convention on the Rights of the Child, the African Platform of Action of 1994, the Beijing Declaration is also referred to there. The United Nations Resolution 1325 on Women, Peace and Security, and the SADC Declaration on Gender and Development. It also refers to the African Union's Agenda 2063, which identifies actually GBV as a major obstacle to human security, peace, and development. And it also makes reference to the African Charter on the Rights and Welfare of the Child, and also the Maputo Protocol, which states that every woman shall be entitled to respect for her life and the integrity, security, and protection of her person at home and in other places. That is the Maputo Protocol, is mentioned in the preamble. And as I say, I highlight this because that key, that is what informed. So when you go back home to your chambers, to your offices, then you can just always know that in order to find the inspiration of the modern law that is relevant even in interpreting the modern law when it eventually becomes law is this instrument. The Convention on the Elimination of All Forms of Discrimination Against Women, otherwise called CEDAW, is also mentioned in the preamble. The Rome Statute of the International Criminal Court, otherwise called the Rome Statute, is also referred to in the preamble. So that is the preamble. That is how rich it is. Now, the preliminary provisions in Part 1 of the modern law consists of matters generally underlying the understanding of the modern law. Member states are required to give effect to the modern law in the course of time. And the expectation is that member states shall, without delay, undertake a process of domestication or legislative reform in their own countries to give effect to this law. Member states are expected to enact and enforce national laws prohibiting all forms of gender-based violence. The emphasis, all forms of gender-based violence that address and punish such violence in line with the international legal instruments. So member states may use any of the following to domesticate this modern law. Any of the following ways. Adopt the modern law as a whole, the whole of it, or adopt this modern law differently, as I said, as a whole, or certain selected provisions of the modern law may be domesticated by countries in accordance with their own circumstances and the state of their own legislative framework. So the application and scope. This modern law applies to all persons. This is critical. The application and scope. This modern law applies to all persons without distinction of any kind, such as race, age, language, religion, and nationality. And it shall be construed to apply to the full extent of the definition of gender-based violence contained in this modern law. The modern law shall apply to offenses committed within the territory of a member state, on board a vessel or aircraft that is registered under the laws of a member state, by a national member state whose extradition is refused on the grounds of nationality. And for avoidance of doubt, it says that it applies to non-cohabiting or non-marital relationships, individuals with family relationships to one another, sexual relationships, members of the same household, including persons related by blood or affinity, and minors. It applies to violence against or between. And this is important to emphasize. It applies to violence against or between heterosexuals, lesbians, bisexuals, transgender persons, non-binary people, and sex workers. And the rights and benefits, protections, and interventions, assistance, and services specified herein shall also apply and be available to victims. And it says in its terms that for the avoidance of doubt, the principles relating to hierarchy of laws and subsidiary of laws and ultra vires shall apply to national laws relating to gender-based violence. We all know in our countries where we subscribe to constitutional democracy that our constitutions are the supreme law, followed by statutory law and regulations and so forth. So it does make mention of that. But the other point that you may find interesting, at least the magistrates and others found interesting, is the extraterritorial jurisdiction of national laws. It says that a member state shall ensure that any law on gender-based violence shall have extraterritorial effects as to meaningfully give effect to certain obligations and commitments by member states. So it shall have extraterritorial effects. It has a useful section on interpretation, just like most laws do have. And lawyers always find this section very useful. The interpretation section, no matter how many years you have practiced law, no matter how many times you have been a prosecutor or a lawyer or a judge, you always find that you will have to return repeatedly to definitions. So it has a section on definitions, and I will highlight a few critical definitions for your information. Anti-gender based violence. It defines domestic violence, for instance. It says domestic violence means any action or omission based on gender perpetrated by a family member, underlined, the consequence of which cause or may cause harm, which cause or may cause harm. A prosecutor will be interested in that wording. Which cause or may cause harm or suffering to a woman, a child, whether physical, psychological, sexual, economic, including death, injury, deprivation, and sexual abuse. So it's a very broad definition. It also defines consent. Consent in rape is key. It's one of the key defenses or elements. And it says consent means the voluntary, informed, and unequivocal agreement of the victim to engage in the sexual activity in question. The unequivocal. And it also defines gender there as meaning the roles, duties, responsibilities which are culturally or socially ascribed to women, men, girls, boys, and gender. It's not the same thing as sex. That is socially ascribed attributes, gender. It also defines gender-based violence as meaning all acts perpetrated against women, against men, against girls, and against boys on the basis of their sex, which cause or could cause harm, physical, sexual, verbal, emotional, psychological, economic, and so forth. So, and it also speaks about gender stereotypes, harmful practices. And it says that harmful practices relate to, it means customary, traditional, religious, or social practices that negatively affect or behavior or attitude or rights which threaten or may threaten the health, social welfare, dignity, physical or psychological rights, including practices and prejudices based on the idea of inferiority or stereotyping roles of either sex or gender. So the interpretation is very critical to your work. And it defines also marital rape. You may find in our jurisdictions, I don't have the statistics, you may find that maybe in some jurisdictions, marital rape, there is no such thing as marital rape. And in some jurisdictions, there is such thing as marital rape. But the SADC model law defines what marital rape is. And it says it means any unwanted sexual act by a spouse or ex-spouse that is committed without the other person's consent. So in terms of this model law, if it is eventually domesticated and becomes part of the national law, we may see a situation, a uniform approach in SADC countries where marital rape is criminalized. It's not currently criminalized in all the jurisdictions. There is also sexual harassment is defined there. And I know in various countries, the definitions are a bit different in terms of how sexual harassment is defined. This definition of sexual harassment in the SADC modern law is derived from international legal instruments, and it says it means any unwelcome sexual advance, request for sexual favor, verbal, display of images or physical conduct or gesture of sexual nature or any other behavior of a sexual nature. It also speaks about sexual and reproductive rights of women. And we know how issues of sexual and reproductive rights in our region are serious in terms of whether women really control their bodies. And the modern law defines sexual and reproductive rights as meaning the universal human rights relating to sexuality and reproduction, bodily autonomy and integrity, and safety of the person, the right to sexual privacy, the right to make free and responsible reproductive choices, the right to sexual information based on scientific inquiry. If we were to unpack what that definition means, we'll spend the whole day here. But for purposes of the presentation today, you can see how broad the definition of sexual and reproductive rights is, that you as prosecutors, you can take note of going forward. It also defines the victim, who is a victim. And it says a victim means a person who has been subject to gender-based violence or discrimination, or who individually or collectively has suffered harm, including physical, emotional, mental, and so forth. So that is the part one that I said I'll be dealing with, that provides the general information. I now get to part two. Part two is on human rights-based approach and policy direction. I must of necessity link it with the preamble section, which I'll spend a little bit of time on, insofar as that preamble actually outlines the international human instruments that inspired the modern law, which part two is really about. So part two is about rights protection, and it includes civil and political rights and socio-economic and cultural rights. So it talks about the right to privacy, the importance of protecting the right to privacy, human dignity, equality, access to information, access to justice, the right to education, which we all know that gender-based violence affects the right to education, especially of the girl child, the right to health. It has very pregnant consequences in terms of affecting these rights. The right to social security and equal protection of the law. It addresses issues of discrimination, and it poses the obligation on the government that the government, a competent authority, which includes the prosecution, a service provider, shall not discriminate against a victim on any of the impermissible grounds. And those grounds are listed in that section. There are several of them. They include, you can't discriminate based on ethnic, statelessness, nationality, refugee status. You can't discriminate because someone is a refugee. And you can't discriminate against a person by using any distinction or any exclusion. So the modern law is very clear on those rights, especially the obligation on a government that must lead by example. And the DPP or the prosecutors are such an important structure in government that they should leave the law as it is. And when eventually this modern law is enacted into law, they must live its provisions. The prosecutors must live its provisions. So there is access to justice. It says a victim has a right to access justice. A victim has a right to execute judgment against the state. And it says that a judicial institution shall not order any security for costs in matters relating to gender-based violence. It also speaks about the right to fair trial and settlement of complaints. In the last engagement with the magistrates, a few points arose out of whether, as I will indicate later on, the requirement that a trial may proceed in the absence of a perpetrator. They ask questions on whether that is fair or whether that offends fair trial. There is issues around whether if someone is being heard through video link in some faraway place away from the physical building of the court, they ask the question whether that offends fair trial. So I know, having worked with prosecutors for almost all my life, that issues of fair trial are critical to your work. So the SADC model law deals with the right to fair trial and settlement of complaints. It says a victim has a right to a fair trial before a judicial institution and to have a dispute or complaint decided timeously and fairly. Timeously and fairly. And it says that a law enforcement officer, yourselves, shall ensure that a trial for a gender-based violence is commenced without unreasonable delay. I know that is easier said than done, because in many of our countries, the function of many things, including availability of resources, but this is aspirational, and it speaks to that aspiration. It says a person is entitled, as I say, that the trial must be done expeditiously. A victim is equal before the law and shall be entitled to equal protection before the law. The victim has a right to privacy. The victim has a right to dignity. The victim has a right to respect. And that speaks to the fact that as prosecutors, it's all too easy, actually, to pile more trouble on a victim by the manner in which we treat the victim. So we need to be alive to the right to privacy and the dignity and respect the victim. A victim's inherent right to liberty and security. A woman shall not be discriminated against with respect to the provision of housing or any attendant services, and access to information. A victim has the right to access information held by the state or another person which is lawfully required for the exercise of the protection of the right that that victim has, meaning that we should be willing to share information that the victim may require of us. By us, I'm talking about prosecutors, require of us. We need to be, if that information is lawfully required, we should desist from the all too common habit sometimes of being reluctant to share information, even if it is information that can help a victim. And this particular model law is very much victim-centered. And other than those rights, the right to that I have mentioned, there are also socioeconomic rights here, the right to health. And when you talk about sexual reproductive health rights, the right to health is particularly implicated, and this model law speaks about those rights. The right to nationality. A woman has the right to confer her nationality onto her children and spouse on an equal basis with men, the right to asylum. Every woman has the right to asylum, including a right to asylum due to gender-based violence. So this is critical, including the right to asylum based on gender-based violence, in line with the relevant conventions and principles of international law. It also speaks of the rights of vulnerable women and children. Women and children with disabilities, orphans, migrant women, and unaccompanied migrant children, refugees or asylum seekers, stateless persons, and other vulnerable persons shall enjoy all the rights of women and children specified in the model law. And it obligates government to put in place policies and measures and interventions in collaboration with the police to assist and protect vulnerable women and children, especially victims, take into account the increased risks. So that was part 2. Part 3 deals with access to justice, a space where you, the prosecutors, are present and play a critical part. Access to justice and procedural protections. That speaks to you. It speaks, of course, to judicial officers. But it says this: a victim shall be treated with compassion and provided with all the support for him or her to regain control. So you shall treat victims with compassion, understanding, and sympathy. And it says a law enforcement officer shall ensure that a victim statement is taken promptly. So this speaks to you, prosecutors. You shall ensure that a statement is taken promptly in a professional and non-judgmental manner. And victim, you must then be sensitive to the circumstances of the victim. So in taking the statement from a victim, you shall not impute to the victim any improper conduct or conduct yourself in any manner that actually makes the victim worse off. You shall record accurately, read back to the victim, and the content is confirmed by the victim. In other words, what you record must be confirmed by the victim. It also says that you shall ensure that a medical legal examination is arranged, if appropriate, and is done in a timely fashion. Gender-sensitive manner that takes into account the unique needs and perspectives of the victim in a respectable manner, and ensure that all available evidence that can lend credibility to the allegation is collected, and is collected in a respectful manner that maintains the dignity of the victim, including the following: promote evidence building that focuses on the credibility of the allegation rather than, as we often do, focusing on the credibility of the victim. Consider whether forensic examinations are required, and if so, they shall be done in a timely manner and with due respect, except that virginity testing, two-finger tests, and other procedures that draw inferences on the victim's sexual history or consent are prohibited by this model law. You must ensure the scene is visited in a timely manner as prosecutors, and the scene is viewed and protected to preserve the evidence. If scene viability is confirmed, a thorough crime scene examination shall be undertaken. So you can see how exhaustive, and I spent a little bit of time on these aspects because they speak to you, the prosecutors, about how you go about your work. And it may well be that we don't capture everything, and we will need your input as to whether what we have made provision for in this model law makes sense, whether there is a way of strengthening it based on your experience, because this is in effect the essence of our meeting today. It obligates you to gather evidence, to store it, to process it professionally, and to make sure that evidence analysis reports shall be reviewed and used to determine the next steps in the investigation or prosecution process. And based on the findings, follow-up action shall be taken to conclude the case without undue delay. And ensure that when working with victims who are girls, that services are tailored to the unique requirements of the age of the girl, and ensure that interview rooms and interviews are gender and child friendly, and where necessary or appropriate, ensure anonymity, ensure confidentiality, and that your procedures are child sensitive, that the non-offending parent or guardian, legal representative, or appropriate child assistance authority is involved. Bear in mind always that a victim is entitled to access the mechanisms of justice as provided in the model law. So it's very extensive, and I have just highlighted a few key ones. And it says that the responsiveness of the judicial processes to the needs of a victim shall be facilitated by, among other things, by informing the victim of the role, the scope, timing, and progress of the trial. So you must always keep the victim appraised about how far the investigations are, how far the trial is, what is the next step, and how long it may take. And you must allow the views and concerns of a victim to be presented and considered at appropriate stages at the proceedings where their personal interests are affected. And you must take measures to minimize inconvenience to a victim, protect the victim's privacy where necessary, avoid unnecessary delay in the disposition of cases. We know the problems of delays. Witnesses die, witnesses forget, and ultimately that has a bearing on whether you may get a conviction. And whether or not you may get a conviction has implications for justice, as we all know. So we need evidence that is credible, that is high quality evidence, and the model law speaks to all those. And says all law enforcement officers, concerned institutions shall carry out appropriate investigations into gender-based violence issues. The victims are entitled, they have certain entitlements in terms of the model law. And these are the following. A victim shall be entitled to, has the right to reasonable, accurate, and timely notice of any proceedings, is entitled to be notified if the perpetrator is going to be released, is entitled to be notified if the perpetrator has escaped for obvious reasons. A victim has a right to be informed of his, her rights, her remedies, and support services on how to obtain them, including information on how to participate in criminal proceedings. And there is also the right to safety. And I think Linda spoke about the right to safety and privacy, and to be free from hardship during investigation, during the prosecution of a matter, during the hearing. The victim should not be subjected to additional hardship. And ordinarily, hearings are to take place in an open court. And where in gender-based violence proceedings in a court, the court is satisfied that there are special circumstances that make it desirable, and that in the interest of justice, that the proceedings or any part of the proceedings should not be held in the open, that may be done. And I think also by parity of reasoning, the obligation should not only be on the court or the judicial institution or the quasi-judicial institution, to use the language of the model law, but also I think prosecutors as participants may take that view and bring it to the attention of the court. That is in hearings in public. And it does speak about possible interventions where a person applies to a judicial institution relating to a case of gender-based violence for leave to intervene. The court may also issue orders that are appropriate. It speaks about restitution. A perpetrator or a third party who is responsible for the perpetrator's behavior shall, where appropriate, make restitution to the victim, which restitution shall include compensation in monetary form. And it also speaks about financial assistance from the government, that when restitution is not fully available by the perpetrator. In other words, this model law envisages a situation where a victim may need to be compensated monetarily, but the perpetrator has no money to do so. This model law is so progressive as to suggest that in those situations, the government may step in to provide restitution, monetary compensation to the victim. It speaks of procedures and legal services to ensure access to justice. A service provider shall ensure when attending to a victim that they are non-judgmental, they are supportive, and you proceed in a manner that prevents secondary victimization. And you respond to the victim's concerns and allow the victim to tell you his or her story freely without undue interruptions. You must allow victims to express their views and concerns according to their abilities, according to their age, according to their intellectual abilities. Because as people, we are different. Sometimes maybe those that tell their story in a manner that may challenge your focus, your concentration, your attention. But we are required by this law to be patient, to listen to everybody in a manner that will bring the best out of that process. Mediation shall not be permitted in any case of gender-based violence before or during judicial and quasi-judicial proceedings. That's what the model law says, that mediation, nope, there shall be no mediation. We know what mediation has done. We know that people have dropped their cases to proceed, and the prosecutors have always had some challenges. So the model law says mediation shall not be permitted in any case of gender-based violence. And it says marriage shall not be a competent decision in case of sexual assault or rape cases, or due to the woman or girl being pregnant as a result of the sexual assault. And it initiates many other rights of victims during judicial or quasi-judicial proceedings, including the following that are critical, I think, for you as prosecutors. It says that the victim shall have the right throughout the judicial or quasi-judicial proceedings to decide whether or not to appear in court or submit evidence by alternative means, including drafting a sworn statement or affidavit, requesting that the prosecutor present relevant information on her behalf or submit a taped testimony. And when appearing in court, give evidence in a manner that does not require the complainant or victim to confront the defendant. So that must be able to be facilitated. Where the victim in a trial, let's say of rape or some other form of gender-based violence, feels he does not want to confront the perpetrator, he or she must be enabled to do so. And is also entitled to protection within the court buildings, including separate waiting areas, separate entrances and exits, police escorts if necessary, and staggered arrival and departure times, so that he doesn't arrive at the same time with the perpetrator or leaves at the same time with the perpetrator. That will only make the victim relive the trauma that he has gone through. It says that evidence relating to sexual reputation of the complainant shall be inadmissible as evidence. Evidence relating to the sexual reputation of a complainant shall be inadmissible. We know, and they may well be, you know better than me, there may well be some jurisdictions to date that still allow the sexual history of the victim to be brought to court as part of the defense of the perpetrator. This SADC model law says that shall not be the case. Any law, customary law, practice, or religious rule or practice shall not be used as a ground of committing gender-based violence. So you can't use customary law, you can't use your religion or religious convictions to perpetrate gender-based violence. And any sentence or penalty imposed shall match the gravity of the gender-based violence. And for purposes of this law, a matter of fact shall be taken to be proved if it is established to reasonable satisfaction of the court. If it is established to reasonable satisfaction of the court, it shall be deemed to have been proved. Now, I will speak to gender-based violence-related offenses that the model law speaks about. A person who, it says, who removes an organ from any person's body, that is gender-based violence-related offenses, takes away the child from the lawful mother of the child after she gives birth, without lawful authority makes, produces, or alters any identity or travel document, obtains or procures, destroys, conceals, removes, and withholds whatever may be necessary in a trial of GBV, that is what is called other gender-based violence-related offenses in terms of this model law. There is a part that is more judicial, but since again you are part of that machinery, for you to be allowed to, it says that a judicial institution shall take into consideration And because usually you also as ministers of justice, you can bring to the court's attention certain things that the court is not doing properly. So this particular section of the model law helps you to be able to better serve the ends of justice. It says that a court shall take into consideration the following factors: whether the offense involves serious injury or death of the victim may be taken into account. The offense involves a victim who is particularly vulnerable, let's say a pregnant woman. A victim was deprived of liberty. A victim is mentally handicapped, and the offense involves more than one victim. That may have certain consequences bearing on a sentence that may fit the offender, that may fit the crime, and that may fit a society. So it also says no criminal liability when subjected to gender-based. It says a judicial institution shall not hold a victim criminally liable for an offense committed by the victim if the offense was committed by the victim as a direct consequence of being subjected to gender-based violence. I repeat that one. It says that a court shall not hold a victim criminally liable for an offense which the victim has committed as a result of a direct consequence of being subjected to gender-based violence. So I'm sure you have views to express on this. It also speaks of child victims and so forth. So that gives you an overview of what the gender-based violence model law speaks about. And due to time constraints, I think that gives you a fair summary. And you may have a lot to say, and I'll allow you because we'll be moving into plenary. I'll therefore, before I conclude, just spend about a minute or two highlight some general offenses that the model law speaks about. It says a person, except a victim who is a woman or a child, who refuses to answer any question asked, questions asked for purposes of an investigation, or gives an answer which is false or is misleading, commits an offense, or fails to produce a document required for purpose of an investigation, commits an offense, or willfully signs or delivers any false, incorrect notification or report, commits an offense, or willfully moves a victim out of the jurisdiction or place of safety, or fails to comply with any order or warrant issued under this law, commits an offense. Because I planned to end at 12:30, I have 1 minute to conclude. And in concluding, I try to bring together the threads that I have highlighted in giving you the overview of the SADC model law, and make about 5 quick points. One being that this SADC model law, as we say, it sets standards and principles based on international human rights. It's soft law, is persuasive in nature, and once adopted into national laws, then we hope that it could be enforced. And you, the prosecutors, play a critical role in ensuring that it is enforced. As I said, it will not be binding on member states in its current form, but you can use it as a resource. Each state is free to pick and choose provisions that are appropriate to its own circumstances and its own history. I thank the Director of Proceedings for permitting me this time, who is myself, and also thank you for your kind attention. And now end my presentation and move into the next stage, which is plenary, for you to comment on any ideas that you may have relating to the model law, with particular focus on how you think we can improve this model law, or whether your experiences as prosecutors, we have not accommodated them, because we would like to accommodate your experiences in this model law so that it can best serve the ends of justice. Thank you very much for your kind attention. The floor is open. I don't know whether it's you, Kurasha, or Ronald. Just take note of those who raise their hands and just mention their names, and then they can speak, even without me saying the names from this side.
Noted. This, there is Christina.
Yes, go ahead, Christina. Go ahead, Christina.
Yes, I think it's for me. Christina, please.
Christina.
Yes.
Yes, Christina.
I think she's frozen.
Yeah, I can't hear her.
Good afternoon, everyone, and good afternoon to me.
Yes, you have the floor. Please proceed.
Yes, I do apologize. I'm having some internet connection issues. So I'll proceed, and if there's any issue, I'll type my question in the chat box. So good afternoon, everybody, and thank you, Professor, for the presentations, and thank you to previous speakers for their presentations. Indeed, this law is very comprehensive and does address a lot of aspects, and which of course are going to be useful not only to prosecutors, but as well to legislators and to the different authorities involved in gender-based violence. I have to say that I've just joined the office of the DPP in Mauritius. So I do not have as an extensive knowledge as perhaps some of my colleagues in the audience. But I do have two remarks from the presentations that have been made. So the first one relates to actually the law just makes a difference between the credibility of the victim and the credibility of the allegation. Now, as matters stand in Mauritius, it's about the credibility of the victim that matters. And often, even though all the processes are followed, so we have a proper investigation, we have a proper handling of the victim post the assault, the part where we fail to actually convict the perpetrator is when the victim fails to come to proof to court. And this is actually based on a very simple and practical reason, which is based in our code of ethics in Mauritius, which is that we can't actually coach victims. We can't talk to victims beforehand. Now, you will appreciate that this actually has a lot of repercussions, because it means that throughout the court process, the victim is not accompanied by a lawyer, and we only see the victim on the day of the trial, when we are basically asking the victim to give his or her evidence in an environment they do not know, in a way they do not know, because they don't know how to testify, what are the things they're going to be asked from the defense. So what we have seen in practice here in Mauritius is that there is a concept called the watch and brief that has come in place. The watch and brief being a sort of an amicus curiae. So it's a lawyer who represents the rights of the victim, but who does not intervene during the court process. He's merely there to assist the victim. So that would be probably just my first suggestion, to allow this space, taking into account the limits that we have as prosecutors, that we cannot interact with the victim, to instead give a space to watch and brief, amicus curiae, to allow the victim to tell his or her story with the full latitude that he or she should have. That's the first thing. And the second thing that I'd like to highlight, again, based on my very little experience here in Mauritius, is about the mediation part. So the model law says, of course, that mediation is not possible. But in our process, often when the victim comes to the hearing for the protection or prohibition order, he or she will be asked by the magistrate in very sort of forceful terms whether they are going to find an agreement with the perpetrator. So I think this concept of that mediation will not be possible is actually a step in the right direction, because we are focusing on not settling for the sake of settling. But at the same time, there should be some flexibility, because, of course, we are talking about family lives, and sometimes they want that flexibility to be allowed to resolve the matter and not proceed in court. So that's my two remarks, and I thank again everyone for organizing this session and for all the speakers for their valuable input. Thank you.
Yeah. Yes, Judge. We also have Tanya and Shimangazo. You are muted, Judge.
Yeah, let's hear Tanya.
Thank you, colleagues. This is actually not Tanya. She is my colleague. We share the same link. I'm Advocate Pierre Smith from the National Prosecuting Authority, South Africa. Thank you ever so much, Mr. Chair and Professor Dingaka, for your valuable overview and presentation. Much appreciated. And I share my previous colleague from Mauritius for the inputs by other colleagues also provided. I have a couple of questions. They're not necessarily long questions, but I would like to shoot. In relation to what was specifically mentioned in the model law, and it is on section 34 that deals with the procedures and legal services to ensure access to justice, which are to be followed by prosecutors. In South Africa, we've included in our curriculum a focus on social context awareness training, which actually assists the prosecutors and police officials on how their behavior should be implemented in relation to when they deal with victims of these offenses. So it's a focus on behavioral attitude and responses by these colleagues. We call it social context awareness. I assume this is in relation to what was included in the model law. I've also noticed it in section 50 on page 110, where it deals with the response to GBV complainants by prosecutors. It seems that is the focus that you wanted to specifically entail, the social context awareness that needs to be adhered to by prosecutors. If so, well noted. The second point that we would like to have in relation to the domestication of the model law in South Africa, for instance, and as you know, we've got quite progressive pieces of legislation dealing with different aspects of gender-based violence. So, but for us, the Constitution is the ultimate top law, so to speak. All other pieces of legislation needs to pass the constitutional muster or scrutiny. if there is, for instance, in the model law, something that we consider to implement, but it is in conflict with our law, and obviously, if to be implemented in conflict in the Constitution, then obviously we won't be able to implement it. How will that implement, or how will that affect the implementation of certain aspects of the model law for us in South Africa? Then what I've also noticed in relation to the model law, that's section 50 on page 110, subsection 3, that deals with the specific, let's call it, direction that the prosecutor shall not refuse to institute GBV, gender-based violence prosecution. Does it mean that the discretionary power of a prosecutor is herewith removed in relation to gender-based violence? In other words, the dominus litis focus of a prosecutor is not to be implemented, so a prosecutor does not have that discretion not to institute a prosecution, and it might be on the merits of the case, say for instance, there's insufficient evidence. We did notice that in the same subsection, it was said that if a prosecutor wants to discontinue, he or she shall not discontinue unless the Attorney General consented. Should that not have been included also, or a similar managerial aspect for the prosecutor that should not refuse a GBV prosecution? Then what was also an interesting point for us, and that's section 76 in this model law, the Anti-Gender-Based Violence Fund, or alternative financial resources. How is that to be applied? Does it mean that if, for instance, because it obviously hints towards in the direction of compensation, that if a victim of a particular case and made a case and the alleged offender is prosecuted and found to be guilty, only then will she or he be able to apply for this anti-GBV fund or alternative financial resources? Is our understanding correct in that regard? Then another point, we've noticed that the model law makes extensive provision in part 7 on page 130 to the usability and of data or essential statistics collation, much supported by us, because we found, for obvious reasons, that in South Africa, in many instances, that data assists us immensely to determine trends, and specifically also an increase or decrease in certain areas of gender-based violence related offenses. But specifically, if there's an increase or in GBV hotspots, this information can be utilized very successful by prosecutors when submitting arguments in court for aggravation of sentence. So much welcome that part specifically. Another part that we found quite interesting is section 31. It refers to intervention orders. Now, if my understanding is correct, it means that a person can apply for leave to intervene in a judicial process or quasi-judicial process, where that person has got facts or certain information that has not yet been presented in the court or at the quasi-judicial process, and then the presiding officer, either the judge or the quasi-judicial presiding officer, does have that discretion to allow for that intervention order to be successfully applied. And I would assume then the person can present that evidence. How is that supposed to work? We don't have that provision in the South African law. Then in relation to, I think I've covered that, the evidentiary. Oh no, I didn't. I want to talk about that. Section 36, evidence and evidentiary procedures. If I read the section 36 correctly on page 95, it states that for the purposes of our law on gender-based violence, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of a judicial institution or quasi-judicial body. In South Africa, in criminal law, we work on the process of beyond a reasonable doubt. Now, it seems to me that the reasonable satisfaction is a more relaxed or a less strict test to be applied. Maybe somewhat similar to civil law, where we're talking about a balance of probabilities. Is my understanding correct? And do we work indeed on a more relaxed test, for instance? Because reasonable satisfaction sounds to be less strict than beyond a reasonable doubt. And it also seems to be more subjective than an objective overview of facts. I think, thank you, Doctor and Chairperson, much appreciated for allowing me the time. Those were the questions from our side. Thank you for your indulgence and your good presentation previously. Thank you. Over and done.
Thank you very much. Much appreciated. There are many questions coming. I'll allow one more question, and then we attempt to respond to the questions that have been tabled. Pardon?
Chimangazo will take the floor.
Chimangazo.
Yes.
Chimangazo, the floor is yours.
Good morning, everyone. I'm not sure if I'm visible from your side.
What is visible is a very sumptuous, a photo of what looks like a very sumptuous meal. Not your face. Yes.
I'm sorry about that. I would not know how to remove the meal.
It's not offensive. I know that some people might be hungry. I'm sure the judge will not mind. You can proceed so that we don't lose time.
Okay.
Yes, let's proceed.
My name is Chimangazo Kagaza. I'm from the National Prosecuting Authority based at the DPP office in Johannesburg. Just before I started speaking, I saw my colleague, Advocate Pierce Smith, was on the floor, and he covered several issues that I wanted to raise. And I'm only left with one. Dr. Chairperson, I think I heard you through the proposed act that women would be sort of like, if you are not telling the truth, you are a victim of an offense and you are not telling the truth, or it is perceived that you are not telling the truth, then you will be prosecuted and criminalized. So I just want to find out from the chairperson, how do we intend to implement such piece of legislation? Mostly because it has been found that victims, even the speaker, the first speaker who was presenting, to say that victims tend to blame themselves, and in more cases they don't indicate exactly what happened to them. So and that goes to this the social aspect, the trauma, and so on. So if now we include criminalization of their silence, don't we think that we are going to victimize the victims more on the proposed legislation? How do we intend to implement that? I'm saying that further, taking into consideration that in South Africa, we have got progressive piece of legislation. Just one to quote the Sexual Offences Act. It embraces all that has been discussed this morning, but I believe that we'll have a difficult way of implementing what is proposed today, criminalizing the victims, if they are not comfortable yet to disclose or to say what happened to them. I'll refer you to our section 14 and 15 that deals with children. Most children, they don't disclose, fearing several things here in South Africa. So the proposed, if I heard you, Chairperson, very well, will indeed criminalize the silence that the woman maybe women feel that I am not ready as yet to disclose what happened to me. And I'll pause for now. Thank you.
Very well. I think I'll allow one last question, and then we'll attempt the responses. Yes, there's a hand up.
No, that's an old hand.
Oh, it's
Judge.
an old hand. Okay.
There are
So,
no questions at the
okay.
moment. Yeah, there are
Okay.
no hands at the moment.
Okay. Then I will attempt to respond to the questions. I start with a disclaimer. The disclaimer is that I'm no expert of the gender-based violence law, let alone the modern law. But a few things need to be highlighted, some of which I have mentioned at the beginning. They answer some of the questions, if not all. So they are of general nature. So I'll start with those of a general nature that should answer some of the questions. The modern law is an aspirational document, proposed law. Is based on what is considered the best practice. And there is an explicit understanding that its provisions may not all of its provisions may be attractive to countries. So there may be situations where country A or country B or country C may be uncomfortable with a particular formulation or even the logic of a particular provision. If you recall, I earlier said some countries who think that it's excellent law, its provisions, the way they is crafted, they may domesticate it as it is. But a number of countries, I'm sure, will choose certain provisions that they consider strengthen their laws or do not contradict their fundamental laws, such as the Constitution. So that is the nature and character of the modern law. It's meant to set up standards. It's meant to articulate standards and principles which we consider are consistent with international human rights law, because at the center of it all is human rights. But we may find that there are certain provisions of it and even the formulation that is unappealing to some countries. In those circumstances, those countries are free to disregard those provisions they are uncomfortable with and only take on board only the provisions that they are comfortable with. So it's a resource, it's a reference materials, if you like, and they can pick and choose the provisions they like as they wish. So that is by way of general contextualization. So I go back in terms of an attempt to respond or comment on questions that were asked. I start with Crisinta from Mauritius. I think she spoke about, she made two remarks, basically. One that drew attention to the difference that the gender-based violence model law makes a difference between the credibility of the victim and the credibility of the allegation. I think she applauded the focus of the model law that is on the credibility of the allegation than the victim, but said that in Mauritius, the focus tends to be on the credibility of the victim. And I don't think it's just Mauritius. I think it's in many jurisdictions where that is the case. So you see a deliberate attempt by the model law to shift the emphasis to the credibility of the allegations. And you also mentioned one point, I think, watching brief, where a lawyer may come in under a watching brief to assist the victim with no rights to intervene in the trial. I think it's an attractive proposition as far as I'm concerned. And I think you also spoke to the issue of mediation, which the model law prohibits. And I think you were of the firm view, which I think has been noted. SADC PF would note it, and I'll note it, that maybe we need some flexibility to introduce to the mediation. So that is my response to your answer. And then there were a series of questions that came from my friend in South Africa. I missed the name. It initially came under Tanya, I think, because they share a link, but he made it clear that he's not Tanya. Spoke about several aspects of the model law, but I think one of the things that he spoke about, which they are doing in South Africa, is the social context awareness, which I think is what exactly the model law speaks about. And on the second point that he made was on domestication, saying that the constitution in South Africa is the mother of all laws, is the top law. That is the term that he used. And that is the case in many countries. And the implications are also the same for most of the countries, meaning exactly what he said, that any law that is inconsistent with the constitution would be invalid to the extent of that inconsistency. So what it would mean, if there are any provisions of this model law that run foul to the constitution of South Africa, they would be entitled to disregard it on that ground. So that is my broad answer with respect to that. If there is inconsistency, of course, the Constitution of South Africa will take precedence. So those aspects of the model law that are inconsistent, South Africa or any other country for that matter would have difficulty taking those provisions on board. I may not have taken all his concerns into account. Others who may wish to comment on what he said, they may do so. But the one that I've also noted is he was worried about the discretion that seems to be taken away from the prosecutor when it comes to prosecuting GBV offenses, saying that it does take away the discretion of the prosecutor and wondering whether it is wise to take away the discretion in that absolute terms, or we should find some way or mechanism of ensuring that it is not totally obliterated. I think this is a point that is noted, and we'll see whether we can add anything to the model law to obliterate. I mean, not to obliterate, to mitigate to take away the discretion in its entirety, or if the intention is to do that, then it shall remain in place as is, and then the countries will have the latitude either to accept or to reject that kind of provision. I think he also talks about the anti-GBV funds. How are they going to be applied? Is it my understanding is that they would be applied on a case-by-case basis. I'm thinking that where a perpetrator has been found guilty and may not be able to provide restitution, for instance, that may be one circumstance where that fund may come in handy. He supported the use of data, so I have no comments on that. And also talked about intervention orders. Persons can apply to intervene where a person has information that has not been presented in court. And then the court may, in its discretion, use it. Exactly at what stage, how it is supposed to work, I think is one thing that maybe we may have to relook into it and see whether we want to make any provision. I would say to him that if he has some ideas on how that could be improved, maybe he can deposit it in the chat box and we can look at it and whether we can sharpen that particular aspect. He also spoke about reasonable satisfaction as being a less strict test in terms of his understanding. I think he also said that it's also not an objective test. I think it seems to me too that a reasonable satisfaction test is obviously a lower test than the one that we are used to in criminal law, that the state must prove the case against the accused beyond reasonable doubt. So clearly that will be a lower test, and whether or not countries are willing to water down the locus classicus, the test that has stood the test of time, is a matter for debate, but I agree that it imports a lower standard. The matter that was raised by Kakaza, I think it's an advocate from Johannesburg, if my notes are correct, was concerned about criminalizing maybe not telling the truth or keeping silent. I think that provision may also need to be looked into from the angle that you are looking, you have just suggested, whether it can be done in order to ensure, what can be done in order to ensure that that does not happen, to criminalize silence. But I'm sure it meant to apply to certain cases where the suppression of the truth may meet all the requisite standards of a criminal offense. Thank you very much. That's what I could say. But if there is any other comment from anybody around that, is free to add something. I see our time is about to end. Any other comment to what I've said, or enriching what I've said, or subtraction before we move on to the next stage is most welcome. Any other comments? If there is no any other comments, anyone wants to say anything? Linda SG, anything you want to say? Or Kurasha? Anything? Am I being heard the other side, or?
Nothing from me.
Oh, okay. Okay. No, thank you very much. Then that then moves us to, if there are no questions, we'll move to the next stage, which would be actually the end. So I'll call upon. Let me just check the. Yes, the concluding remarks. Then, if there are no other remarks, will be made by Mr. Feifa. I apologize for butchering the pronunciation if I have butchered it. Is the program officer from the Justice Section at the United Nations Office on United Nations Drugs Office Headquarters. Mr. Feifa, if you are available, you are free to take to the floor to give us your closing remarks. The floor is yours, Mr. Feifa, and apologies if I have done injustice to the pronouncing your name. Hello? Have I lost everyone?
Stephen, are you able? We can't hear.
No, sir, we can hear you clearly.
Huh? Stephen?
Hello?
There's something happening with Stephen's connection. We can't hear him. I can see lip movement. I even can read the lip movement.
Can you hear me now?
Yes, we can hear you. Thank you very much.
Yeah, I had to pull out and replug my microphone, so that luckily helped us. Thank you very much, Director and honorable delegates, honorable Secretary General, honorable justices, and distinguished prosecutors. All protocols observed. Ladies and gentlemen, I wish to commence my concluding remarks by expressing my gratitude to all of you for taking time out of your busy schedules to contribute to this important consultation session on the development of a model law on gender-based violence. The importance of this process cannot be overstated. Gender-based violence, and particularly gender-based violence against women, remains one of the most widespread human rights violations, not only in SADC member states, but virtually in all countries of different regions across the globe. In fact, the data that we have at the UN level confirms that every third woman worldwide experiences gender-based violence at one point in her lifetime. Gender-based violence also remains a major impediment to achieving gender equality, development, and peace. And this model law represents a critical opportunity that all of us have to take up and step up practical efforts towards the eradication of gender-based violence in the SADC region in particular. The COVID-19 pandemic is making the situation worse. In many countries, confinement and lockdowns have increased violence risks, while women's access to essential services, to essential police and justice services as well, have been reduced. to protect women's rights, COVID recovery strategies, both at the national and international levels, must prevent and respond more effectively to gender-based violence and strengthen the rule of law. Allow me to welcome, however, the increasing commitments among member states to better prevent and address gender-based violence. Some 150 countries recently pledged their support to the call of our UN Secretary General Antonio Guterres for a worldwide domestic violence ceasefire in response to the COVID-19 crisis. And global political commitment is also evident from the fact that the elimination of gender-based violence and ensuring access to justice for all is indeed at the heart of the 2030 Agenda and its Sustainable Development Goals, notably Goals 5 on gender equality and Goal 16 on peace and justice and strong institutions. I welcome the references that were made today to international conventions and standards pertaining to the elimination of gender-based violence. The international standards and norms in crime prevention and criminal justice are particularly relevant for issues that were discussed in today's meeting. And I'm thinking in particular about the instrument mentioned earlier by Linda, which is called Updated Model Strategies and Practical Measures on the Elimination of Violence Against Women in the Field of Crime Prevention and Criminal Justice, which reflects the consensus of all UN member states. This instrument contains detailed guidance not only for the legal, political, and institutional framework of the justice sector towards the elimination of gender-based violence against women, but also for its implementation in practice by prosecutors like yourselves and other criminal justice professionals. First and foremost, states have the obligation to exercise due diligence and to take measures to eliminate impunity and provide protection to survivors and empower them to recover and obtain effective remedies. It must be noted that a failure by state institutions and officials alike, a failure to fulfill this due diligence obligation violates and nullifies the enjoyment of survivors' human rights and fundamental freedoms. Effective crime prevention and criminal justice systems that respond to gender-based violence in line with international standards must be centered on the rights of victims and survivors, must ensure offender accountability, and importantly, adopt a human rights-based approach. States are responsible for creating and implementing a legal and political framework in which everyone's human rights can be enjoyed and exercised, including protecting victims and survivors of gender-based violence, as well as ensuring defendants' right to a fair trial. This also means that survivors must be treated with dignity and respect throughout the criminal justice process, rather than, as unfortunately often is done, treating them as objects of protection or mere sources of evidence. Any laws, strategies, and responses should be based on the understanding that gender-based violence, particularly against women, is both a cause and consequence of gender inequality, as well as a violation of women's human rights. The wider dynamics of inequalities between men and women create gender-specific vulnerabilities. Issues such as economic and legal dependency impact on survivors' willingness to report or to cooperate with the criminal justice system and prevent them from breaking out of the cycle of violence. It bears noting that gender-based violence cuts across income brackets and different levels of education, different strata of society. Therefore, all actions that we take need to recognize and address the root causes of this type of violence, such as structural inequalities between men and women, and discrimination based on sex, intersectional discrimination based on different and additional factors such as age, ethnicity, disability, or sexual orientation, as well as an understanding of the gender dynamics of power and control. Furthermore, negative gender stereotyping is reflected in the social values, cultural patterns, and practices of the criminal justice system that have traditionally minimized violence against women or indeed blamed victims themselves. Ladies and gentlemen, this model law provides an excellent basis from which SADC member states can reform their crime prevention and criminal justice response systems. In pursuit of this, the promotion and protection of women's and girls' human rights should form the basis of the development and implementation of relevant national legislation, policy, and training programs. I wish to specifically recognize the efforts that have been made to develop this model law and mainstream human rights and a strong gender perspective in all aspects of the draft. The draft is a great output that is relevant to the local needs and contexts, and it does reflect the dedication and commitment of SADC and its member states towards the elimination of gender-based violence in the region. And I applaud you all for this. UNODC, my office, remains committed to continue to support and assist SADC member states as they embark on the process of domestication of the model law and the reform of their criminal justice and crime prevention systems. We value the partnership with the SADC Parliamentary Forum and the Technical Working Group. We will be pleased to build on our long-standing experience in supporting member states to address violence against women, violence against children, human trafficking, and other forms of gender-based violence. In closing, allow me to make these few points for your consideration. Firstly, I think that it is imperative that all justice actors take appropriate measures to prevent hardship during the detection, investigation, and prosecution process in order to ensure that survivors are treated with dignity and respect, whether they participate in the criminal proceedings or not. Secondly, it is equally important for criminal justice agencies to do no harm. Attitudes of criminal justice officials that foster, that justify, or tolerate gender-based violence must be held up to public scrutiny and sanction. And thirdly and finally, I would like to recall that prosecutors are often the gatekeepers in criminal justice proceedings, and they hold substantial power that should be exercised to increase the likelihood of successful conviction of perpetrators, to protect and empower survivors of gender-based violence, and to send a message to society that gender-based violence will not be tolerated. I wish to thank the Director of Ceremonies, all speakers, attendees, and the organizers of this event, as well as our interpreters, and I thank you. Merci beaucoup et muito obrigado.
Thank you very much, Mr. Feifa. Thank you so much. I think your concluding remarks are loud and clear, and I think they serve as a reminder of the critical role that we in the justice sector play. And I think the takeaway message from what you have said, among many others, is that we should do no harm. We should do no harm, and we should try our very best to serve the ends of justice. And to serve the ends of justice, you correctly said, we must honor human rights of every person, the right to dignity, to respect every person. And as you say, prosecutors as gatekeepers are powerful. They are very powerful and influential in the way we could address and attend to matters of gender-based violence, especially the last point you made, sending a clear message that this will not be allowed. And part of sending the clear message is that we conduct proper investigations, we collect evidence properly, we prosecute professionally, independently, without bias and without prejudice. So thank you very much for reminding us of those. I think they are very powerful messages that every one of us here will take home. So it is my pleasure to thank also everyone, all the participants. I see that we remained almost constant at around 42 or 41 throughout the day. So we are grateful. Thank you, Secretary General. I don't know whether Mr. Kurasha, there are any in-house announcements you want to make. If you don't have, the meeting will be adjourned accordingly. Mr. Kurasha?
We do not have any announcements, Justice.
There are no announcements. Secretary General, you want to say anything before the meeting is closed?
Just to say thank you very much, and we continue to await any feedback that you'd like to send. The email is gbv@sadcpf.org. If you have any other additional comments you'd like the drafter to consider. Thank you very much, sir. Great meeting.
Thank you very much, everybody. Much appreciated. The meeting is accordingly closed. You may now leave the meeting, I'm sure. Thank you, everybody. Thank you so much.
Thank you. Bye-bye.
Thank you and
very
goodbye,
much.
colleagues.
Thank you.
Bye-bye.
Thank you.
Thank you. Thank you, everybody.
Thank you. Goodbye. Thank you.
Thank you very much.
Merci beaucoup.
Merci
you very much.
Obrigado.
Thank you.
Merci beaucoup.
Goodbye.
Thank you.
Okay. IT kindly terminate.